Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk a little bit about the Alexandre Bisonnette decision out of Quebec. That's at the Quebec Court of Appeal. 6 or 7 of you sent me articles about this. A bunch more had questions about it. So it's on everyone's mind. If you're not familiar with what happened here, he won at the Court of Appeal, and that reduced his sentence in terms of the period of parole ineligibility from 40 years down to 25 years. Note that he's serving a life sentence, so that lasts until he dies, but it means he can start applying for parole after 25 years instead of 40. There are no guarantees, however, that he gets parole at that time. I'll talk about that a little bit later. So what had happened is at the trial court level, the Crown had asked for 150 years of parole ineligibility, and they didn't get that, but the court had a bit of a problem because essentially the way the law was written required either sort of 25-year steps. And the court found that that was unconstitutional, that violated Section 7, which is the right to life, liberty, and security of the person, and Section 12, which is cruel and unusual punishment, but didn't throw out the legislation entirely that allows for consecutive periods of parole ineligibility. What the trial court judge did was read in a new option. So they created a new option in order to try to save the legislation, and thus imposed a 25-year period followed by a 15-year period and a bunch of other 25-year periods to be served at the same time. So that got to a total of 40 years of parole ineligibility, which is a long time. Now, both sides appealed this decision. This is what we call a cross appeal, and that means that both the Crown and the defense each had something that they wanted to see changed about this decision. The defense position was that the court should have found it unconstitutional entirely and should have essentially imposed a 25-year sentence. As you may have guessed, this is what the court ultimately does at the Court of Appeal. The Crown had said that they should have upheld this provision and imposed a 50-year sentence, or 50-year period of parole ineligibility. So looking at this, there's some interesting things going on here that I kind of want to highlight. I did a first video along this where I went through a lot of the case. It came out to about 45 minutes, and frankly, I think that's a little too long for this particular decision. So rather than going through this case, I'm going to give you a very broad summary, which hopefully will answer a lot of questions, but I'll link to the case as well. And if you have more questions, please let me know in the comments below. I try to answer as many as I can, but there's a lot of comments these days, but I will try to keep up on this one. So one of the things that happened here is there's a moment where the court sort of calls bullshit on the Crown. And I kind of want to highlight that because I think it's a very relevant bit that shows sort of some of the thinking going on here. So I'm just going to flip over to that. So they note here, they say, in a particularly detailed judgment, the trial judge thoroughly summarized the evidence and stated that, pursuant to Section 745.51, the Crown had requested that he sentence the appellant to 6 consecutive 25-year periods of parole ineligibility for a total of 150 years. It should be noted that, on appeal, the Crown contests this perception, stating that it never suggested such a lengthy period. According to it, at most it requested that the provision be applied, yet the Crown's application manifestly amounted to seeking a term of 150 years. In fact, that is what everyone understood. As it appears, however, the Crown has modified its approach on appeal, seeking instead the addition of only 1 consecutive period of 25 years for a total of 50 years before the appellant is able to apply for parole. In this regard, this is what the judge had to say on the Crown's point of view. The language here is a little awkward because this is a machine translation, but I read a machine translation more easily than I read French, so that's what we're going to go with here. So translation. If Alexandre Bisonnette were to be sentenced to life imprisonment contingent on serving 150 years of the sentence before being eligible for parole, after causing the deaths of 6 people in less than 2 minutes while experiencing certain mental problems, what sentence could be contemplated hypothetically for someone having stabbed 10 people at a shopping center? 250 years of ineligibility? 350 years? What about a hitman who, strictly for financial gain, killed 25 people over a 10-year period? 625 years of ineligibility? 800 years? There's a reason the judge mentioned 800 years, to demonstrate the excessiveness of the Crown's suggestion. The Crown is therefore grossly mistaken in writing, in its memorandum, we deplore the excess reflected in the trial judge's arguments, where he hypothesizes periods of 800 years, which is light years away from the period of 50 years acceptable to the Crown. In making this statement, it is distorting the judgment while denying its own arguments because a period of 50 years was not acceptable to the prosecution at first instance. So what this means is that at the trial level, the Crown had clearly asked for a period of 150 years of parole ineligibility. And now at the Court of Appeal, they're saying the trial judge was so unfair to us because he's talking about this ridiculous position and we would have been okay with 50 years. And so the trial judge is not being fair when they, go through these hypotheticals, appeal court, fix it, fix it. They're being mean to us. And the appeal court is not having it. They're saying, listen, you asked for 150 years. You clearly asked for 150 years. That's what everyone understood. That's what everyone knew you were doing. You don't get to now back away from that and pretend you never took that position in order to make the trial judge look stupid. No, we are calling you on your bullshit here. So and I'm using stronger language than the Court of Appeal did, but this is about as strong language as the courts typically engage in if they're not sort of actively finding that you've engaged in some sort of malfeasance. So this is fairly strong language where the court is not happy with this approach that's been taken. The other thing that's really worth looking at here is that the court in several places sort of distances itself from Mr. Bisonnette specifically, because they say, Mr. Bisonnette is terrible. However, we need to look at the constitutionality of this legislation in general, also considering sort of hypothetical people who are not Mr. Bisonnette and how they'd be impacted by it. And this is the correct approach, in my view. They reference, and in my view correctly, the case of the Queen and Nur, which is a Supreme Court decision that I will eventually do a video on because it's also very firearm related. So they're saying Mr. Bisonnette might be the least deserving person that we can find for this reduction. However, we have to consider other possible people, and so that's one of the things they're going to do. Now, one of the things we have to also look at is why do they find that, there's a Section 7 and a Section 12 violation? So they look at a little bit of the history, and they look at how the death penalty was abolished, and in its place was put a period of life imprisonment with parole ineligibility for 25 years for first-degree murder. Now, 25 years at the time was seen as a long time, but they did not impose life without the possibility of parole. And so one of the things the court makes some noise about is how they're saying, listen, we're not giving you life without parole because that would have its own constitutional problems. What we're doing is we're just saying you can totally apply for parole in 150 years. And the court says they have some problems with that. It's kind of Kafkaesque to say you can apply for parole long after you're dead, because of course nobody's coming before the parole board if they are dead. So the court has an issue with that, and they basically point out that this seems to be a bit of an end run around saying, life without the possibility of parole. The other thing they point out, and there's some expert evidence, that sort of illustrates this, is that it's really difficult to contemplate where somebody's going to be in 25 years, because sometimes people get parole because they have genuinely made steps to rehabilitate themselves. And I'll note that when you're on parole, it's not like, okay, you're out, you're free, no worries. You're still under heavy monitoring, and they can actually pull you back in off of the parole, even without you necessarily having committed a new crime, just if they think that you're not sort of being managed in a suitable fashion. So they can actually drag you back in to serve more or potentially all of the rest of your life sentence. And you will never be free of that monitoring so long as you're on a life sentence. You will always be, having that follow up. Now, this, this becomes a bit of an issue here when we're talking about, predicting the future, because at the time of sentencing, we don't know what somebody's going to be like in 25 years or 40 years or whatever. This provision isn't intended necessarily as a punishment aspect, or they differentiate this from revenge, because they note that some people might find this to be suitable for revenge reasons, but revenge isn't really a basis for our sentencing. It's denunciation, deterrence, and I kind of think that the denunciation is kind of close enough to revenge that the court's differentiation here might be a bit of a problem. But, when we think about 25 years, if I think about 25 years ago, and you told me, hey, you're going to be a lawyer and you're going to be making videos that are going to be seen by, tens of thousands of people, I would have thought that you were a crazy person. I might have seen if you had a cup and maybe tried to put some money in it. If you asked me what I was doing, where I'd be in 40 years, go back 40 years ago, I wouldn't have had a whole lot to say because I would have been a very young infant. We also don't know what rehabilitative measures will be in place in 25 years or 40 years. And another reason why people sometimes get parole is that sometimes their dangerousness has been reduced, not necessarily by them becoming better people, but just by them becoming sort of incapacitated. So somebody who is, in a wheelchair and on oxygen and unable to sort of function, becomes a lower risk of committing murders simply because they can't. So that becomes another reason for parole, and the system is often happy to get people who are sort of medically incapacitated out of prisons because they're very expensive in prisons. So that becomes another sort of reason for parole. But the court sort of rests its hat in part on this notion of protection of hope of release. And so they note that the courts had previously not accepted this argument, but they point out that somebody who's in custody who has some prospect of eventually being able to apply for parole is going to have a psychologically different experience in custody than somebody who has no prospect. It also means that somebody, if there's no chance that you can ever be released, there's no point in actually undergoing any rehabilitative measures. So they mention that as well. But they also talk about the dangerous offender provisions, and dangerous offenders can be sentenced to an indefinite sentence. So potentially they can be held in custody for the rest of their lives. And they note that that was not ruled unconstitutional because there's a review of the offender's situation by the parole board 7 years after their detention, and thereafter no later than every 2 years. So because they had that option for a review, that's why the dangerous offender provisions are not unconstitutional. So that also provides something that they said indicates that, for instance, a period of 75 years of ineligibility would be cruel and unusual. Now, whether or not you agree with this, whether you have much care about the psychological impact on the offender is, people debate this. People debate, the death penalty. However, it's doubtful that the death penalty would be found to be constitutional in Canada, even if Parliament attempted to reintroduce it. I have my doubts as to whether a life in prison without parole would be found to be unconstitutional. So all of these are sort of things to consider here. With respect to the Section 7 argument, they essentially found an overbreadth issue. And the reason why is that Parliament had talked about how they wanted to sort of target certain specific kinds of bad actors. And they mentioned people like Robert Pickton, Clifford Olson, Paul Bernardo specifically. Now, when they do that, one of the things that occurs to me is that if you're listing people like that, Mr. Bissonnette's name adds onto that list without, any problem. Nobody's going to have any issue with his name being added to that sort of roll of very notorious offenders. But again, the court is saying we're not just looking at Mr. Bisonnette here. We're looking at the constitutionality of this law generally, and there may be individuals who are not Mr. Bisonnette who are targeted by this. And so they found that this provision is overbroad, that it targets people who are maybe not as deserving of this, and therefore that's a constitutional problem. The court rejected the notion of sort of reading in the sense of fixing it in the way the trial judge did to allow like a 40-year bit instead of a 50-year bit or a 150-year bit. And they essentially said that this was too far, in its revision, and that essentially this comes down to not just the court fixing a small problem, but the court writing its own legislation. And the courts don't like to write legislation because that's not the role of the courts. The role of the courts is to interpret and to apply, but not to create legislation. So they said that this would be a job for Parliament to fix and not for the courts. And so essentially what they're doing when they refuse to do that is they kick it back to Parliament and say, this is broken, please fix it. And Parliament often will then come back and amend it in some fashion that, that works. Now, in terms of, let's sort of consider the practical implication, because the result of all of this is that they struck down this legislation, in Quebec at least, and possibly in other places if this ruling is upheld in other areas. You can't impose consecutive periods of parole and eligibility anymore. So Mr. Bisonnette, his period of parole and eligibility goes down to the 25 years for a first-degree murder. Now, the impact on Mr. Bisonnette, it means he can apply for parole after 25 years. Practically speaking, it's probably not going to matter to him, because if you're Mr. Bisonnette, it probably doesn't matter if your period of parole and eligibility is 25 years or 50 years or 800 years or 5 minutes, because I think a parole board is going to be very, very unlikely to parole somebody in his situation. When they think about the sort of risks versus benefits here, the risk of somebody who's committed this kind of offense is very high because they're not going to want a repeat. So I think they're going to be very leery of releasing him. I suspect most likely that Mr. Bisonnette is going to die in custody, regardless of the period of parole and eligibility. So ultimately, I don't think this changes his chances of getting out. Now, there is some impact on the victims, because the victims, instead of waiting 40 years to start having parole hearings that they're going to end up attending and presenting their view on, which of course is going to be traumatic, that's going to start in 25 years. Now, there's ways that that impact can be mitigated, but the victims are not going to be happy with this this result. The people who survived or the people who lost family members, they're going to be unhappy with in 25 years. Now, 25 years is a fairly lengthy period out, but still, there's going to be people sort of experiencing some direct fallout from that. The next thing is to look at what is going to happen with this, because, what are the next steps? And I am, notwithstanding the fact that this was a unanimous verdict, so, I suspect that the Crown is going to want to appeal this because they're not going to be happy with this, with this declaration of law. So I suspect that this is going to go up to the Supreme Court of Canada, and that the Supreme Court is probably going to take this case because I think it's a big deal. I think this is one that the Supreme Court is going to want to decide on. And ultimately, if I was a betting man, I would say that my suspicion is that the court is most likely to grant the appeal and to go with the trial judge's version of things. That is my bet if I were to be placing money on this one. My secondary bet, if I were to place, a secondary bet on this one, would be that they uphold the decision of the Court of Appeal. I think the least likely thing is that they say, okay, you know what, we're fine with these consecutive sentences, but this isn't one where I'd want to place bets of actual money, because I'm not sufficiently confident in that. This is just my hunch, my feeling on that, and I'll acknowledge I'm a defense lawyer. I tend to believe in rehabilitation because I've seen rehabilitation from some fairly surprising people. I've had a client who I met in the community who was, he was out on parole on a murder bit. This is, and, I think properly. There's, it's very difficult, in my view, to say that people are beyond rehabilitation. And in my view, the parole board tends to be pretty good at assessing it, because we actually have a very low rate of recidivism. So people committing new offenses from people who are out on parole for, particularly for murders. The chances that people commit another murder are almost vanishingly small, to a degree that paroled murderers as a category commit fewer murders per capita than the general public, which kind of suggests that they are lower risk, that the parole board are doing a pretty good job. But this is not going to be a popular decision. A lot of people are already very upset by this, particularly because Bisonnette is not an individual who tends to be deserving of much sympathy. I will actually point out one additional argument that came up here, which is Bisonnette tried to tender some new evidence, which was some video evidence, to contradict one witness, because that witness had testified that Bisonnette had shot at children, and Bissonnette's argument was, I very much tried to avoid harming any children. And one of the things the court found is that the video evidence would actually have contradicted the evidence that was given at trial. However, they declined to take this new evidence because they say, listen, it doesn't matter, because you're saying you were trying to avoid harming children, but you pled guilty to attempted murder charges that included specifically allegations that you tried to kill 3 children. So you don't get to plead guilty to attempted murder on children and then also claim that you were trying not to hurt any children. This is incoherent, and essentially the same way they told the Crown, lay off your BS, they told Mr. Bisonnette, we're not taking your BS here either. So the Court of Appeal sort of handed out a fair number of, no, that's not going to fly here. Anyway, I hope I provided a little bit of explanation here. I hope that people understand this case a little bit better. Again, leave questions in the comments. I will link to the full decision here, and so that you can go over it if that's what you want to do. Thank you for watching. I hope that, this has armed you with some knowledge. And I want to thank my Patreon supporters, because YouTube is not going to like this video based on the content, so this is entirely Patreon supported. So thank you to $10 Patreon supporters: My Buddy Keith, Process Eng, Stephen Larson, Mark D, General Counsel of the CCFR, as well as John Robinson, Tim Rogers, Roy Haddock, Freckles-Dack, Jean-Alexandre Tessier, Cameron Johnson, Sir Goat, Sights and Arms Limited, Chaba Hollow, Peter H., Craig Kwan, Akin Coxall, North Central Process Service, Toys Are for Boys, Ian Vaughn, Milan Vrakic, Terrence Griffiths, Doug Thompson, Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Michelle Stotzel, Scott Sweetman, Mike Rhodes, Alvaro Bataille, DF, Stacey Cartmel, Tactical Advantage TV Canada, Ian S., Dave Leslie, Juan, Donald Duncan, Stefan Conquest, Darren Duell, Sean Crane, Ian Hutchinson, Rory, Travis, BC Bushcraft Leather, John Singarty, Misa Komarevich, and at the $20 level, Kevin Fleet and Dale Nesbitt, $30 level, Steve Browning, and at the $50 level, George, Demo, and People of Canada. Once again, thank you. Your support makes videos like this possible, and I hope I've provided a bit of explanation. See you guys next time.